Lordships to start with the proceedings. I request petitioners to start with the arguments.
The council seeks permission to close the case.
Check. The council seeks permission to address the bench collectively as the Lordships. Much obliged. Lordships, this is Council 1, appearing on behalf of the respondents in the case of the Democratic Reform Project versus the Union of Bharat. The Lordships, Council 1 will be taking 20 minutes to substantiate on the first 3 issues, and the co-council will be taking 20 minutes and will be reserving 4 minutes for refusals. The council seeks permission to narrate the facts in brief. Much obliged. Your Lordships, Bharat Nadu is a diverse and a populous nation. Following the increase in the crime rates and lack of resources, the government, in collaboration with BNMIL, developed Yugadrishti and AI tool. This particular tool helps in predicting recidivism by analyzing historical crime data compiled by the CRB of Bharat Nadu, and it is applied in the pre-trial detention, bail, and sentencing. Laws were passed to facilitate the implementation of the same. This particular AI is known to have bias despite having high accuracy. Your Lordships, the democratic that has challenged the constitutional validity of inculcating this particular AI as to this particular AI is infringing the fundamental rights, that is Article 21 and 14 of the Constitution. Your Lordships, if the bench is satisfied with the narration of facts, the council will proceed with issues. Your Lordships, the respondents have not contested the maintainability pursuant to their written memorials that has been exchanged. Hence, the council will proceed with the second issue framed in the current case. Much obliged, Your Lordships. Your Lordships, the second issue that is being framed in the current case is with regards to the use of AI algorithm in the pre-trial detention, bail hearing, sentencing that violate the right to fair trial under Article 21 of the Constitution of Bharat. Your Lordships, the whole right of fair trial is explicitly mentioned under Article 21 of the Constitution of Bharat. The right of fair trial would mean that trial before an impartial judge, an impartial prosecutor, and in an atmosphere of judicial power. Your Lordship, there are multiple facets to this right, namely presumption of innocence, an impartial tribunal, adversarial system which the Constitution of Bharat Nadu follows, reformative justice, lack of prejudice, and biases. Your Lordship, the council will further devolve into how each and every facet of fair trial has been infringed in the present case. Your Lordship, the council will proceed with arguing this particular issue in 6 points. Firstly, being the adversarial system. Your Lordship, the whole concept of adversarial system is that both the prosecution as well as the defense have to be given equal opportunity, or rather, putting it in other words, should be equally equipped in each and every case. Your Lordship, this is reiterated in various cases. For example, in the case of Mrs. Kalyani Bhaskar versus MS Sampurna, Zahira Habibullah Sheikh and others versus the state of Gujarat, which has been cited in our memorials, Your Lordship. Your Lordship, however, in the current case, the algorithm, that is the Yugadrishti AI, is an undisclosed and is a blind sliding element to the judiciary. Your Lordships, the accused, this particular argument can be substantiated by the line that has been quoted in para 14 of the moot proposition, Your Lordship. This whole concept of AI works on a black box system, which means the algorithm and the data that is being fed in is not transparent in nature. Your Lordship, hence this particular AI tool is violative of this facet of this particular right. Next, Next, moving on to the most important fold of my argument, that is lack of prejudice. Your Lordship, the lack of prejudice is seen in compliance with free and fair trial. This connotes that impartiality, neutrality, and lack of biases. Your Lordship, the object of the whole criminal procedure code of the country itself is to ensure that the accused person is getting a fair trial, which is being reiterated in the case of Willie Sandy versus State of Madhya Pradesh, which is being tagged in tag 39 of the compendium, Your Lordships. Your Lordships, in the present case, there are two types of prejudices that has arisen, and the Council will substantiate our same. Firstly, the collection of data procedure is not reliable. To substantiate this fold of my argument, I would like to direct the bench to tag R4 of the compendium. Your Lordships, tag 4, Your Lordships. It's in an invariable color of peach, Your Lordship, tag R4, quoted below. Your Lordships, peach color tag below, Your Lordships, tag below, R4. Your Lordships, the collection of data solely is done by the Crime Bureau of Bharat Nadu, which has been stated in para 12 of the moot proposition, which is in pari-nexia with the NCRB. The particular report elucidates that the data that has been collected by the same body is unrepresentative, biased, and non-exhaustive in nature. Your Lordship, the second fold which proves prejudice is the parameters that the AI uses or is assigning to arrive at the decision that is prone to be prejudicial. To substantiate the same, a report in tag R2 has been tagged, which states, Your Lordship, the whole concept of AI is to eliminate human bias. But what is to be pondered upon is, are we actually eliminating human bias, or are we just camouflaging it with technological bias? Your Lordship, this particular report enumerates as to several recidivism model where there were prejudices regarding the decisions with in parameters that were taken into consideration, like race or like prosecuting the Hispanics. So that particular report is clearly stating as to how irrelevant parameters are used for incrimination. Your Lordship, moving on to Annexure 1 of the moot proposition. This particular annexure clearly indicates as to how the AI tool, that is Yugadrishti, has taken irrelevant consideration, such as neighborhood of a particular person, to incriminate that person. Your Lordship, thus this particular whole system of AI is prejudicial in nature. Your Lordship, moving on to the third fold of my argument, that is privilege against self-incrimination. Your Lordship, the whole right of self-incrimination has been enumerated in Article 20, Clause 3 of our Constitution. Your Lordship, hence, this particular principle has been violated in various senses. To substantiate the same, Your Lordships, in an AI like Compass, which is being used in the USA, most of the data is fed on the basis of a questionnaire that has been posted to the accused. And hence, there are certain parameters where the accused fills those particular parameters. And hence, those particular parameters are used to incriminate the accused. Your Lordship, however, this particular AI, Yugadrishti, coerces a person to give insensitive information regarding their medical, financial, and private digital communication. And hence, this is proven as a self-incriminating factor in the particular case. Your Lordship, moving on to the next fold of my argument, that is presumption of innocence. Your Lordship, this is one of the most basic principles of the criminal law, which establishes that the burden of proof lies on the prosecution to establish the guilt. The court does not presume any guilt. Your Lordship, when a procedure has begun, the judiciary should start any case with a clean slate. However, the AI, in presenting a risk report at the pre-trial detention and bail hearing stage itself, tends to sway the judge away or in favor of the accused. Your Lordship, in such that the moment the particular data has been fed into an AI, it results that the AI takes strong predictors or let's say strong parameters because of the technological models that's being used in the AI Yuga Drishti to create a strong predictor, and hence this particular right is violated. Your Lordship, moving on to the next important fold of my argument, that is reasonable suspicion of bias. Your Lordship, reasonable suspicion of bias is a standard test to determine prejudice in a judicial decision. Your Lordship, in various cases like Shyam Singh versus State of Rajasthan, the court has pointed out that the issue is not whether prejudice is influencing the decision. The fundamental question that rises is whether a circumstance would lead an litigant to rationally believe that the prejudice must have worked against him in a particular case. Your Lordship, Annexure 1 of the Moot proposition clearly states that AI is a biased tool. If the bench is satisfied, the counsel will move on to the third issue.
What are the factors to be considered for granting bail?
Your Lordship, there are three factors that are to be considered for granting a bail. Firstly, is the accused likely to abscond? Secondly, will the accused tamper any kind of evidence? And thirdly, will they influence the witnesses in the present case? These are the three considerations. Your Lordship, the counsel is aware currently about three circumstances, situations.
The foremost thing to be considered, apart from the thing that you
Your Lordship, if the particular accused is going to influence the victim or harm the victim in any way, and is he going to intervene in any kind of judicial proceeding, or is going to be a hindrance in any kind of judicial proceeding?
the charge sheet, whether the report by the police indicates provocation materials of commission of crime. Violated. If you read a charge sheet, you know the meaning of charge sheet. Final report given by the investigator after the investigation is completed.
Indeed, Your Lordship.
For granting bail, the court sees the charge sheet, all the materials collected by the investigator. First look of the charge sheet gives an impression that there are sufficient materials to come to a conclusion that he is so person is involved in connection with that. That is most important. Number three, what you said, comes later. Now, materials are, the prosecutor says, in addition to these materials being available, there are chances of this failure justice, influence the witnesses, tampering the evidence. Now this data, AI data, provides a material to the prosecutor to substantiate the argument and bail should not be granted.
Addressing Your Lordship's question, Your Lordship,
There are materials
indeed,
indicated you important. Secondly, the materials, the AI data, shows that there is tendency to commit crime again.
Your Lordship's directing the bench to para 12 of the Moot proposition, Your Lordships. There are various parameters, as Your Lordship suggested. That
Is there bar for considering those materials or denying data?
indeed not, Your Lordships. Such material factors and evidences can be taken.
How is it violated?
Your Lordships, in the present case, these material evidences are not available to the other party, Your Lordship. Your Lordship, this whole concept of AI works.
It's provided to him. Section 207 of CMPC says that all materials have to provide.
Indeed, Your Lordships. Your Lordships, what the council here is trying to establish is that the parameters that has been fed, as Your Lordship said, that happens in the real world, is not the case in this present AI tool, Your Lordship. The parameters, or let's say the evidences that has been fed into the AI, is a black box, which means that it is not transparent in nature and is not giving you chance of cross-examination to either parties. And hence the risk report that has been arrived into taking such considerations and such parameters into consideration is not scrutinizable, Your Lordship. Your Lordship, further substantiating my argument, this whole AI works on AI algorithms, Your Lordship. Lordships, when an error has occurred in this algorithmic process, it is very difficult for a normal layman to trace as to what parameters were considered or what bias was created while predicting or generating this particular risk report. And hence, that becomes violative of this particular provision.
What do you say that judges get harassed?
Your Lordship, here it's not regarding the judge getting biased, Your Lordship. It's regarding the AI being biased and producing biased information which influences the judge in turn, Your Lordship, which has been indicated in Annexure 1 and Annexure 2, Your Lordships. Indeed, Your Lordships. Your Lordships, in the present case, there are 4 algorithmic models or languages that is being used. Firstly, the random foresting method. Secondly, the logistic regression. Thirdly, neural networks. And fourthly, the support vector machines. Your Lordship, explaining the working model of these particular languages. Firstly, the random foresting method, Your Lordship. Your Lordship, a diagrammatic representation of how this particular model works is tagged in tag D2 of the compendium. Your Lordship, this whole process of random foresting works on different trees, and hence there is a variable attached to every tree. Once the variables are independent in nature, they tend to produce a holistic view and a holistic result. But what happens during feedback discriminatory loop is that one tree tries to replicate the strong predictors, and hence the holistic view is not gained and a biased view is obtained. This is the flaw in the first model. Secondly, logistic regression, Your Lordship. Logistic regression is a linear and an inflexible model. Your Lordship, in a diverse country like Bharatnadu, which has such cultural diversity, the amount of data the AI has to process is huge. And hence, there are subtle differences from case to case basis. Your Lordship, hence, this particular model is incapable of taking subtle differences into consideration to make a prediction. Thirdly, support vector machine. Your Lordship, the diagrammatic representation is again in D3 of the compendium. Your Lordship, this particular model classifies a particular person into a high risk or a low risk offender. However, it works the best in smaller data sets and simple problems. Your Lordship, lastly, neural networks. Your Lordship, this particular technique is basically replication of human cognitive skills, which means there are, as the human brain connects various data and connects various information to arrive at a decision. Similarly, this particular AI language also uses the similar method. Just as humans have biases, this language also has biases inherently because it works like the human brain. Hence, the bias is created and the rights of an individual, let's say the citizens in large itself, is infringed, Your Lordship. Your Lordship, the judiciary of Bharatnadu clearly understands and follows the principle that thousands of accused can be released, but one innocent person should not be prosecuted. When the AI tool is present with so many ambiguities and there's so many reasonable suspicion of biases, such an ambiguous tool, if implemented, would create serious biases and would rather aggravate the burden on the judiciary, Your Lordships.
Suppose this algorithm data of serious information,
Indeed, Your Lordships.
the time of sentence, so section 260 lines. accused at the time of sentencing. That can be made before the previous inspection.
And the lordships, the council is unable to implement this.
However, section 236
Can I refer you lordships? Indeed, your lordships.
the prosecution has to make use of that algorithm, the piece of evidence, or the sentence.
Indeed, your lordships.
Or
Your lordships,
how is it violated?
Your lordships, according to 236, there can be evidences that can be taken after.
This is evidence. The prosecution can make use of this algorithm as evidence.
Your lordship, in this particular case, what happens is this algorithm is so scientific and mathematical in nature that it becomes very difficult to interpret this particular algorithm, your lordship. Lordship, may I further substantiate? Indeed, lordships. The lordships, if the bench is satisfied, can the council continue with the third issue, lordships? Yeah, Your lordships, the third issue is regarding whether the AI algorithm to predict criminal behavior violates the right to equality guaranteed under Article 14 of the Constitution of Bharat Nadu. Your lordships, Article 14 states that the state shall not deny equality before law and equal protection of law. Your lordship, for any law to be passed, this particular law should pass a twin test. Firstly, that is the intelligible differentia, and secondly is the rational nexus. In the present case, there are various intelligible differentias. For example, the race, caste, gender, etc. What is to be noted is if there is a rational nexus sought to be achieved by implementation of this particular law. Your lordship, the council will argue this, substantiate this in two folds very briefly, your lordship. Your lordship, firstly, the data collected has no nexus with criminality. And secondly, the models incorporated into Yuga Drishti perpetuate inequality and biases, which the council just substantiated. Your lordship, the first fold of the argument states that there are irrelevant considerations regarding race, religion, and neighborhood of the accused to convict that particular person. Your lordship, in the present case, it can be seen that irrelevant consideration has been taken according to Annexure 1 and Annexure 2, which has highly influenced the judges to give the prediction. Your lordship, the same has been reiterated in several case laws, like State of Madhya Pradesh versus Babu Bharti. Your lordship, secondly, devolving into one small technicality of this whole AI system, that is the discriminatory feedback loop. Your lordship, the council will illustrate this with a small example. Your lordship, let's consider that race X have more. Your lordship, thus the council 1 would conclude the issue stating that the AI and the law that is being passed are in several folds infringing the right to fair trial and the right guaranteed under Article 14, your lordships. My co-counsel will continue with the fourth and the fifth issue.
Second council seeks permission to oppose the dice.
The council seeks permission to address the bench collectively as your lordships. Your lordships, may the council make a small comment on the issue of the co-council and then proceed with the issues?
Yes.
Your lordship, discriminatory feedback loop is when the data collected out of a biased conviction, a biased sentencing based on the Yuga Drishti data is repaid into the system, thereby initiating a vicious cycle. Hence, the act allowing for the implementation and data collection for Yuga Drishti is manifestly arbitrary and hence violative of Article 14. Your lordship, continuing with the fourth issue, That is, whether the use of AI algorithm raises concerns about transparency, accountability, and due process as guaranteed by the Constitution. Your Lordship, the Council will first substantiate on transparency. Transparency, Your Lordship, is when all data is accessible, available, transparent, and interpretable. Your Lordship, the AI in the current case is a black box AI. Your Lordship, there are two kinds of AI. The white box AI, whose algorithm is available to the public, and then the black box AI, which completely prohibits public scrutiny or disclosure of its algorithm. Your Lordships, there are several cases where AI can be used even in detecting recidivism, as in the case of Compass, where there is a public scrutiny of the algorithm, or at least a selective licensing and selective availability of the algorithm to a monitoring committee, a monitoring team, a team of experts, or legal scholars, Your Lordships. However, in the current case, in light of national security apparently, the AI avoids complete scrutiny of its algorithm. Your Lordship, the Council will elaborate on the consequences of such loss of transparency, Your Lordship. The Council will devolve upon the judgment of Vishaka vs. State of Rajasthan. Your Lordships, tracing the judicial progress of this case, in the Sessions Court of Jaipur, the Sessions Court acquitted all the accused on the grounds of race alone, race and religion and caste hierarchy alone, Your Lordships. However, this ratio decidency was apparent to the scrutiny of the High Courts and the Supreme Court, wherein the landmark judgment of Vishaka was laid down, Your Lordships. However, the AI, its algorithm, its parameters, its models, its weight and its bias is completely hidden from public scrutiny, and hence even the magnanimous fair reasoning of the Supreme Court may be hindered in such a case, Your Lordships. Your Lordship, proceeding with the issue of accountability. Accountability, Your Lordships, is the duty of public authority or an authority in general to perform, and the liability in case of failure. Your Lordships, accountability and openness, that is transparency, are two sides of the same coin, Your Lordships. It means that where there is transparency, the citizens, the people can demand accountability. However, when the processes and procedures in itself are hidden, there is no account or no remedy to attach accountability. Secondly, Your Lordship, there are so many stakeholders involved in Yuga Drishti. The Criminal Records Bureau, which collects the data, the courts which utilize the data, and the team of data engineers who are involved in the development of the algorithm. Your Lordship, in case of bias, it is evidently impossible. It is like locating a pin in a haystack, Your Lordships, to draw an analogy, to even detect where the bias was generated in collection of the data, in processing of the data, or in implementation of the data. In such a case, Your Lordship, passing accountability is near impossible task. The Council will quote the case of DDA vs. Skipper Corporation, Nilapati Behera vs. State of Orissa, and SP Gupta vs. President of India, attached in tab 2, 23 and 33 of the compendium, to elucidate upon the importances of accountability as attached by this Honorable Supreme Court in itself. It has been held by cumulative reading of these cases that even in lack of a direct fiduciary relationship between the government and the citizen, the state still guarantees accountability and transparency to all its citizens, which is severely blindsided by the AI. Finally, dealing with the issue of due process. Explaining due process, Your Lordship, due process was specifically omitted by the Constituent Assembly while drafting the Constitution. However, its Indian variant, that is, the procedure established by law, is explicit in Article 21 of the Constitution. The term due process has been imported into the Constitution by a variety of judicial decisions, including Maneka Gandhi vs. Union of India, Sunil Badra vs. Delhi Administration, and Mithu Singh vs. State of Punjab. Your Lordships, the essence of due process is that any law should be inherently fair, just, and reasonable, Your Lordships. Your Lordship, the Council will contend that the use of Yuga Drishti in judicial process severely impairs the due process, Your Lordship. The Council shall do so in 5 folds. Firstly, oversimplification of complex issues. Your Lordships, the very essence of criminal jurisprudence is flexibility, discretion, human essence of the judges. Your Lordships, citing the case of Ankush Maruti Shinde versus State of Maharashtra in 28 of the memorial. It has been held that ordinarily there are some significant discretion to the judge in arriving at a sentence in each case, presumably to permit sentences that reflect subtle consideration that are raised by the specific facts of each case. Your Lordship, a mechanical algorithm, even if it involves flexible learning, can never take the discretion, the flexibility, and the subtle changes of each case. Secondly, lack of
Yet production of the algorithm. Does it escape the scrutiny by the judge?
Your Lordship, the final discretion is subject to Your Lordship, the judges. However, Your Lordships, there is a term known as conditioning, which means that when a certain report is mandated and is continually used to aid, then there is a chance that the judges might be swayed by the technicality and persuasiveness of the report. Your Lordship. Indeed, Your Lordship. However, opening a black instead of opening a plethora of black boxes, the council would. Your Lordship, everything is available in an abstract manner, Your Lordship. The data is collected in a very opaque manner, firstly. Secondly, it is processed by 4 languages and 4 models, Your Lordships, as elucidated in paragraph 6. As substantiated by co-counsel, each model acts in an independent manner and there is no defining how each model functions and how each parameter is weighed. Hence, opening the black box might induce confusion rather than clarity, Your Lordships. Indeed, Your Lordships. However, as Your Lordships yourself have stated, such evidences are available to Your Lordships, the judges. However, there is no requirement of an AI as a mediator to aggregate all these data. If such aggregation takes place, it takes place in a biased manner, Your Lordships. Your Lordships, the council will substantiate by referring to tag D1, Your Lordships. D1. D1 of the compendium, Your Lordships. Tagged in peach color below. Your Lordships, the parabolic diagram, Your Lordships. Your Lordship, the diagram elucidates how an AI works and the biases and variances generated. As Your Lordships may observe, there is a straight line. This represents the optimal functioning of the AI. Any slight deviation to the right would result in a bias, which is a presumption made by the AI to simplify its processes. Any slight deviation to the left would lead to underfitting, which means that there is a variance between the test data fed and the actual data presented in each case. Hence, Your Lordships, there is no understanding when an AI can go rogue, and there is no scrutinizing whether the AI lies in that optimal single straight line, Your Lordships. That can never be detected.
Do you think that this data will be scrutinized by the court independently?
Your Lordship, independent scrutiny of the data is possible when each data is present.
Or it will be taken to the supplementary to the materials collected by the prosecution. I mean, investigation.
Your Lordships, this is a supplemental aid, Your Lordship. However, it might end up influencing the judicial process. Your Lordships, indeed, Your Lordship. The council would like to quote the words of Bengio, who is the godfather of AI, Your Lordships. He had stated that AI is a good servant, but in certain cases it becomes a very bad master. This is such a case, Your Lordships, where mandating the use of an AI, Your Lordships, this country has a lot of illiteracy, and there might be a case where the prosecution or the defense is not able to bring enough material to the court, Your Lordship. In such a case, supplement. Your Lordship, in such a case, depending solely on the AI might lead to certain conclusions, and combined with the conditioning that the AI poses, Your Lordships. Your Lordship, the Council will also quote certain experiences inferred from the US by the use of compass, Your Lordships. It has been stated that more often than not, the human brain chooses to attach great persuasiveness to the value of the black box, a mechanical box which generates so much of data that the human brain is compelled, psychologically coerced to accept it at some point, Your Lordships.
Yes, proceed.
Indeed, Your Lordships. Thirdly, dehumanize justice. Fourthly, loss of autonomy. Loss of autonomy can be argued in two folds. Firstly, loss of autonomy of the individual, as stated in the case of Manohar Lal versus Union of India, which is the case regarding the Pegasus spyware. The court has stated that continuous surveillance might lead to self-censorship, Your Lordships. Secondly, the loss of judicial autonomy. Your Lordships, the collection of data, its aggregation, the upkeep and maintenance of the AI entirely falls within the executive ambit, Your Lordships. Hence, the executive is significantly bringing a large amount of persuasive evidence to the table and hence compromising on judicial autonomy, Your Lordships. This is against the very essence of separation of powers in Article 52 and also a part of the basic structure of a constitution, Your Lordships. Article 50. Your Lordships, further, this does not fit in the scheme of a reformative justice system, Your Lordship. A reformative justice system is one which tries to reform the criminal rather than merely imprison him on consideration of previous convictions, Your Lordships. If Your Lordship is satisfied with my submission, the Council shall move on to the final issue.
Yes.
Your Lordship, the final issue concerns itself with whether the use of AI algorithm to predict criminal behavior violates the right to privacy under Article 21 of the Constitution. Article 21, Your Lordship, reads, no person shall be deprived of his life or personal liberty except according to procedure established by law. Your Lordship, quoting the landmark judgment of K.S. Puttaswamy versus Union of India, tagged in tag 40 of the compendium, Your Lordship, the case refers to informational privacy, Your Lordship. Your Lordship, the 9-judge bench foresaw the risks of profiling in that case and stated that when offender profiling, that is analysis of the profiles of the offenders is done, it should be done with great caution or not be done at all, Your Lordships. In the present case, according to para 12 of the moot proposition, certain very sensitive data including medical records, social media, online digital footprints, digital communication, substance abuse history, etc. is collected. The very collection itself, Your Lordships, violates the right to privacy. To substantiate the same, the Council will quote the test of proportionality as laid down in the Puttaswamy case and substantiated by several cases like PUCL versus Union of India, Your Lordship. Firstly, the action must be sanctioned by law, which it is. Secondly, the proposed action must be necessary in a democratic society for a legitimate aim. It can be acceded to some extent that in light of crime prevention and national security, it is. But thirdly, the extent of such interference must be proportionate to the need for such interference. Your Lordship, quoting the observation by the 9-judge bench, if there is a nut and a nutcracker, I would choose to crack the nut with a nutcracker rather than by a jackhammer. Your Lordships, in the present case, even if crime prevention is the nut, the respondents have proceeded to crack it with a jackhammer by collecting immense amount of personal and sensitive data, Your Lordship. The Council will dwell upon it in three folds. Firstly, data regarding digital footprints, which is social media, communications, and online activity. Secondly, the evidence regarding bad character of the accused as inferred from previous convictions, substance abuse history, and other medical records. And thirdly, the financial records. And then the Council will advert that collecting information of detainees under preventive detention and even from those who stand in as security for those offenders receiving bail is an overreach, Your Lordship. Thirdly, the Council will contend that obtaining data from history sheet, case diaries and other sources is highly unreliable, and those data being fed into the AI is highly unconfidential. It's a breach of confidentiality, Your Lordship. Firstly, adverting to social media and digital footprints. Your Lordships, in the case of PUCL versus Union of India, tagged in tab 24 of the compendium, the Supreme Court held that the privacy to communication is of the essence and can be violated only in very specific cases in case of national emergency or national interest. Secondly, Your Lordships, in Unique Identification Authority of India versus CBI, the Unique Identification Authority of India, which is the Aadhaar authority, refused to share any details to the CBI on the grounds that this could not be done so without the written consent of the person concerned, and the Supreme Court upheld such a decision. Thirdly, in Anuradha Basan versus Union of India, which is the emergency crisis in Jammu Kashmir and the subsequent curtailing of the right of privacy, here also the Supreme Court emphasized on the right of privacy to be managed and balanced with national security. Finally, in the case of Fahima Shirin, the right to privacy was completely upheld in the case of digital communications, Your Lordships. Proceeding with bad character of the accused, Your Lordships, there have been certain cases which state that bad character of the accused can be taken into evidence only in case the accused himself presents evidence of his good character, which is section 54 of the Evidence Act, Your Lordships. Your Lordships, in the case of Gayala versus Emperor, it was held that the courts cannot look into police records to convict a person. It could be highly against the right to privacy and confidentiality. Your Lordships, police records includes arrest records and such records maintained exclusively by the police regulations, Your Lordships. It is an investigative material, Your Lordships. It is not a bar for the courts, Your Lordship. In fact, there is no bar at all for the courts in any regard, Your Lordships. However, the court has added a word of caution in this case, as well as in subsequent cases, that such documents tend to be highly unreliable and confidential also, like in the case of history sheets and rowdy sheets, Your Lordships. If such data is taken into account, then the data is highly biased, firstly. Secondly, it's a breach of privacy, the right to dignity, and the right to reputation of a person. Indeed, Your Lordship.
Second case, you think what you do that this data will help both as per the nature of punishment to the law in terms of section 75 of the LG section 4.
Indeed, Your Lordship, this data does aid in conviction. However, it can be directly placed from investigation officers to the learned bench. Passing it or using it in an AI algorithm. Indeed, Your Lordship. Indeed, Your Lordship.
At what stage these materials can be get? Suppose can they get it? What stage?
Your Lordship, they can be aggravating or mitigating factors only after the trial, Your Lordships. However, this data, if used in Yuga Drishti, may be used in pre-trial detention, bail, and in sentencing, Your Lordship, which is an overreach. Your Lordship, the presentation of arrest records is permissible under law, but the presentation of data sheets, like history sheets and case diaries, are restricted by law. Indeed, Your Lordship. Your Lordships, as per paragraph 12 of the Moot proposition, a separate law was passed to allow the collection of data from any individual who has been convicted of a crime, instructed to provide security for good behavior or maintaining peace, or arrested in connection with an offence, Your Lordship. If Your Lordships are satisfied with my submissions, the Council will proceed to the prayer after a brief submission. One word. Your Lordships, satisfying the third parameter of proportionality, the Council will adhere to the fourth parameter, which is lack of procedural safeguard. Your Lordship, neither the Digital Data Protection Act of 2023, the Criminal Procedure Identification Act of 2022, nor the IT Act of 2000 provides any safeguard against such surveillance and mishandling of data, Your Lordships. Hence, the fourth parameter of lack of procedural safeguards in case of violation of privacy is also defeated. Hence, Your Lordship, there is a grave case of breach of privacy by using Yuga Drishti. The Council seeks permission to proceed to the prayer. In light of the issues raised,
What are the risks of using artificial intelligence in upholding fundamental rights?
Your Lordships, it defeats the fundamental rights in itself. Firstly, it uses sensitive data like race, which defeats secularism, which is a part of the preamble. Secondly, it curbs the discretion of the judge, which is against the principle of separation of judiciary, which is also a part of the basic structure of the Constitution. Thirdly, it violates the right to equality by placing certain races or certain communities in unequal parallelences to each other. It is almost like the Criminal Tribes Act, Your Lordship, which incriminates a certain tribe just because they are a part of that community. The same bias is perpetrated by the AI. And fourthly, it is against the right to privacy and fair trial as substantiated.
How can other artificial intelligence lead to wrongful convictions?
Your Lordship, it can do so in two manners. Firstly, the AI simply processes the numericals and data collected by way of natural language processors, and hence the bias may occur at data collection stage itself. Second, while data processing, the algorithm is very opaque, so the Council has no comments on the same. However, the models are heavily biased, Your Lordship, as substantiated technically by my co-counsel. Bias may occur in that stage also. The Council seeks permission to advert to the prayer.
Yes.
In light of the issues raised, arguments advanced, and authority cited, it is humbly prayed before this Honorable Supreme Court that the writ petition is maintainable, the law allowing for data collection and implementation of Yuga Drishti be declared void for violation of Article 21 and Article 14, and for any other order in light of justice, equity, and good conscience, the Council shall forever humbly pray. The Council seeks permission to retire. It was an honor arguing before this honorable bench.
Council seeks permission to approach the dais. Much obliged. The Council humbly seeks permission to address the bench collectively as the bench and individually my lords. Much obliged. We are representing the Union of Bharat Nadu in this instant case of the Democratic Reforms Project and others versus the Union of Bharat Nadu. My lords, I will be dealing with the first and second issue, and I will be taking 21 minutes of your, my lords, precious time, and here my co-counsel will be dealing with the third and fourth issue, and she will also be taking 21 minutes of your precious time. With the due permission of the bench, the council seeks to move on to the arguments advanced.
Yes.
Much obliged. My lords, the first issue herein is that does the use of AI violate the right to fair trial enshrined under Article 21 of the Constitution? The Council argues in the negative that it does not violate the right to fair trial enshrined under Article 21 of the Constitution. My lords, I will make good of this argument through threefold submission that the statute made for use of AI is just, fair and reasonable. The second submission would be that the right to fair trial in itself is not an absolute right. And third submission would be there is no direct and inevitable effect on the fundamental rights. Coming to first submission, that the statute mandating the use of AI is just, fair and reasonable. My lord, Article 21 of the Constitution reads, no person shall be deprived of his life and personal liberty except procedure established by law. However, after the Maneka Gandhi case, it has been read as no person shall be deprived of his life or personal liberty except according to fair, just and reasonable procedure established by a valid law. So So what Maneka Gandhi essentially explained was that the right to life and personal liberty is not absolute and can be curtailed in a way which passes the test of just, fair and reasonability. And keeping this in view, it is the humble contention of the respondent that the action of the respondent passes the just, fair and reasonability test. Now coming to what does the just, fair and reasonability test entail? This very quote in the case of K.S. Swami has defined the just, fair and reasonability. It has been defined as, quote, well, a fair trial are certain set of principles in criminal jurisprudence which are available for an accused.
Which are the sections in CRPC dealing with trials?
Well, a fair trial as a fundamental right is
Looking at all these fundamental
my lord,
CRPC is a procedural law.
yes sir.
Where you find the provisions related to trial.
Yes, sir.
Which are the sections?
There are certain sections. I humbly apologize for not quoting the exact sections, but I can refer to the principles which are in CRPC such as
You are arguing a case. You will not be aware of the provisions of right? Relating to trial.
my lord. The question. It is our humble submission that the issue here is of constitutional nature. It is the contention of our counsels that it violates fair trial which is enshrined under Article 20. So
What is fair trial? First because then we say what is fair trial.
fair trial and certain set of principles like presumption of innocence, rights against self-incrimination, which are given to the accused so as to protect him from the might of the state. My lord, as I was dealing with, the action is just, fair and reasonable. As per the definition of Justice K.S. Swami, two aspects come out. That the actions taken should not be excessive in nature. It is humble contention that the actions of state are in no way excessive in nature. Because the final say has been given to the judge. So AI predicts a certain rate of recidivism. So the final say has been given to the trial judge either to accept such prediction or to reject such prediction, and he has to give a reasoned decision for that, which is a principle of natural justice. Moreover, my lord, we have necessitated to apply AI because as of now, Bharat Nadu criminal justice system is failing, as evident from fact sheet, that there has been a rise in criminal cases and the traditional methods have failed. And we have, as by the fact sheet, we have very less resources. So we have no other option but to use AI in expediting, in ensuring the speedy trial, which is a part of which is a fair trial, Now coming to second submission, that the right to fair trial is in itself is not an absolute right. My lord, the council relies upon the judgment of Asha Ranjan versus State of Bihar. It was explicitly held that the right to fair trial is not an absolutely singularly absolute right. When perceived from perspective of accused, it sweeps in the right of victims and the society at large. Keeping this in mind, it is the humble contention of the respondent that the Supreme Court is essentially propounding the doctrine of balance, where fundamental rights of two different individuals are in conflict. Fundamental right to fair trial of an accused and fundamental right of victims and society at large. What Supreme Court opines is that the court should hold the societal interest or national interest at a higher pedestal. So, keeping this to view, it is the humble submission of the respondent that because of an increase in crime in Bharat Nadu, A is the best suited winner. Coming to final submission in issue 1, that there is no direct or inevitable effect. As held by this very court in the case of Maneka Gandhi and Naresh versus Maharashtra, there should be a direct and inevitable effect on fundamental rights to declare a statute invalid or unconstitutional. Keeping this in mind, it is the humble submission of the respondent that the actions of the state in no way overtly or tangibly violate the fundamental rights enshrined in the Constitution. With this, the Council seeks to move on to the second issue. The second issue in hand by law is, does the use of AI violate Article 14 of the Constitution by disproportionately affecting certain communities? By law, the Council argues in the negative, that is, that use of AI in no way violate Article 14 of the Constitution. Well, I will make good of this argument through fourfold submission. First submission would be, under Article 14, laws are presumed to be valid. The second submission would be, AI is conducive for working of a modern society. Our third submission would be, mere hardship is not a ground to challenge constitutional validity of a statute. And fourth submission would be, unintentional and unconscious discrimination is not violative of Article 14 of the Constitution. My lord, coming to first submission, that under Article 14, laws are presumed to be valid. The Council submits that whenever a claimant wants to impeach the constitutional validity of a statute on the basis that it violates Article 14 of the Constitution, it is the duty of the claimant to prove that he has been discriminated by the state and that such discrimination is without intelligible differentia or without a proper reason. Keeping this in mind, it is the humblest submission.
Data is collected in the presence of the accused
Of course, yes, madam. Only after
or in his absence.
Indeed, madam, the data is collected in present of the accused. Only, if I may refer my lord's kind attention to paragraph 12, only the data of prior criminal convicts and who have been instructed to provide security for good behavior. Only these individuals' data has been collected. We are not collecting data of every layman or every.
It's not very clear.
Yes, yes,
It's realistic.
yes,
Where it collects data
yes,
on the accused cases on the likelihood of his being incriminated.
well,
How do you collect it? What is the process of collecting? With his knowledge and without knowledge.
the data will be collected directly from him, madam. Even though the fact sheet is silent about this fact, and the
Where will it get that information?
the fact sheet is silent. How the data is collected from an accused is silent in the fact sheet. But it would be pragmatic to assume that the data should be collected from the accused or a person himself, because he is the only at the stage to give his name, his age, his address. That is the only pragmatic approach here, my lord, since the fact sheet is silent about that.
Giving the name, age,
Yes,
it's not incriminating.
that is exactly the contention of the state, my lord, that it does not amount to incrimination.
Their argument is very data that is collected. It is kept out of the information used against the time of deciding the bail application or sentence. It's violating of different conventions. So where is the show? Where is the material that data is collected?
My lord,
With the knowledge of the accused.
the task of, if I may refer my lord's kind attention to paragraph 12, the task of collecting, processing and preserving, storing, destroying, and sharing and disseminating of the data.
Sharing it for. Sharing it for.
Sharing with the AI technology, my lords. There are two
We
laws.
share with the accused.
There are two laws.
Making representative.
My lords, there are two laws here. One for use of AI and one for collection of data. We are not sharing the data with the accused because it's our responsibility as a
Don't
data.
share. You don't share. How can you make use of the same against him?
My lord, the council would like to argue this in twofold manner. We are not sharing the data with the public at large to maintain his reputation, and a purpose of it. The second submission would be the prediction given by this AI is for the judge to consider a certain rate of recidivism will be assigned, and the judge has to consider if he should be sentenced or not. The giving of such data how that conclusion has been come up by artificial intelligence to the accused himself does not make sense, because the judge himself sees what is the rate of recidivism, whether I should grant the bail or not. Moreover, it is very pertinent to note that this is not binding on nature upon the judge. It is persuasive. What he has to, it is almost exactly as the charge sheet. He has to refer to the charge sheet.
Data is charge sheet. A is charge sheet.
No, ma'am. It is jurisprudentially as equal to that of charge sheet. He has to refer the charge sheet. He has to look at the prediction and still has to give a reasoned decision.
You are sovereign. You are opposed to bail application.
Yes, ma'am.
Who will start the argument for bail application? That's the because it is a
Yes, sir.
He cannot say that looking at the charge sheet there are no materials.
Yes, sir.
He told me that to complete database execution that I am involved with that.
Yes, sir.
He says that
Yes, sir.
you oppose it.
Yes, sir.
You want. The data you have collected, which is not also known to the accused.
My lord, the public prosecutor hearing will not be using the data that is given by AI. The AI is an independent authority. AI is an independent prediction from that of the public prosecutor. The police investigative machinery or the public prosecutor is a separate entity from that of the data. The AI. AI is directly communicating with the judge, and public prosecutor is also communicating with the judge. The public prosecutor must not be confused here with the AI. This is humble submission.
This is the part of it.
Yes, ma'am. It is a part of fair trial, my lords, because ensuring speedy justice is a fair trial, and we
We
are
are not executing justice. We are on bail application. Decided bail application. Trial has not yet happened.
yes, ma'am.
It is the duty of the IMO to narrate all the progress in the investigation.
Yes, ma'am.
He has to state in his remand application as to the data of collection by the university. Is it not the duty of the university to reveal the same in remand application? Is it not the duty of the IO to reveal the same in remand application?
My lord, the
Once he has to remand the court has to remand the accused from time to time.
yes, ma'am.
After 14 days, court has to assign reasons for extension of judicial custody. Then the IMO has to convince the court that there are prima facie materials against him.
Yes, ma'am.
Then he has to place the materials before the court
Yes, ma'am.
as to the data of collections collected by the Yugadrushti.
My lord, it would be humble submission that the AI system directly communicates with the judges. The IO hearing does not have any connection with that of the AI.
If it is so, it is a violation of Article 21.
If it is so,
If it is so,
of
it is
course,
a violation of Article 21.
we are not disputing that. If it is so, that is why we have separated IO from that of AI, and we have made AI accountable directly to the judge. The judge has to consider, it is in discretion of the judge to either consider or to reject AI, the prediction of AI. There is no relation between the investigation officer and that of the prediction of the AI.
How does Yugadrushti data ensure transparency and accountability in the criminal justice system, thereby safeguarding fundamental rights?
My lord, that issue, this third issue, will be explicitly led by the co-counsel, shall be dealing with the third issue. My lord,
You forget bail during trial. When you make use of something, the prestige and passing a sentence, when you make use of something which the accused is not aware,
my lord,
suppose, and make the
yes,
X is an accused who is convicted of 302 offenses.
indeed,
One year.
indeed.
In the second case, he is held guilty at the time of passing sentence. The prosecution will say, it is already a conviction against one case. The accused may say, no, I am not convicted. That is when the prosecution has provided the case number in which the already convicted. It is not provided. Then they accuse us. There is no conviction. So, but we this university data is not provided to the where is it available? You are at the stage of passing standards. Or is it not unilateral?
My lord, it is a humble submission that the basic tenets of the code of criminal procedure are followed. He will be, the accused will be furnished with a copy of the charge sheet. Everything will be written in the charge sheet. The criminal procedure will go on as it is, as of the status quo. The only difference that will be that the judge will have an extra aid from AI in expediting the trial process because of the criminal justice system.
Judicial interest of data.
Sorry.
Extra aid, judicial interest of data.
My lord, assume it is not, but assuming it is in prejudicial interest of the accused is still free to go in front of the trial judge and say that, my lord, I belong to certain set of community, I come from a certain geographical location. Please be careful while considering the data given by AI. Considering this, the judge has to give a reasoned decision. The judge has to write down what is he considering. So, keeping this in mind, the judge will of course maintain that. If I may refer my lord's kind attention to paragraph 18. So, what paragraph 18 explicitly maintain of the moot problem explicitly maintain that if the results are leading to potentially unjust result, that the law maintains that judge has the final say. If the accused says, I am at disadvantage here, the judge will undoubtedly consider the prediction of AI in minimal manner.
That must be only when the accused has got an opportunity to demonstrate that data is not correct.
My lord, we
Not
have,
only the judge can take a decision.
my lord, we have defined what is data. We have defined what will be collected. The accused is still free to go to the judge and say that I am belonging to so and so place, I am belonging to so and so race. So please, I am disadvantaged. So please consider the AI prediction in minimal manner. In respect of paucity of right, the council seeks to want to issue proof. My lord, the issue to hearing is whether a use of AI violates the right to equality under Article 14 of the Constitution. I will make the council argues in the negative that it does not violate because the laws under Article 14 are presumed to be valid until the claimant proves that there is that it is a class legislation which they have failed to prove. The second submission would be AI is conclusive for modern society. While the council maintains that the action of the state no way abridges with Article 14 of the Constitution, arguendo if the bench is to say that it is discriminatory, the state has a reasonable classification which is it is conducive for working of a modern society as held by this very court in the case of Transport and Dock versus Union of Mumbai, where if it is conducive for working of modern society, if a policy of state is conducive, then it is a reasonable classification. Third submission would be the mere hardship is not a ground to challenge constitutionality of a law. The state accepts that there might be a smallest chance of bias. So, however, we are taking all of the possible measures to ensure that it is not biased, and so because the AI might be of hardship for a certain community is not a ground to strike down a law or is not a ground to challenge a law. The fourth submission would be that the unconscious and unintentional discrimination is not violative of Article 14. It is a submission that last point that unintentional and unconscious discrimination by the state is not violative of Article 14 as long as the state is willing to correct it. The state is willing to correct it through manifold manner. The first one would be that the Yukadrushti is constantly updated, redefined based on the feedbacks of the legal scholars, that the AI is statistically proven by data that it is more accurate, that the state government has taken all possible steps to minimize potential bias in prediction. With this, the council directions his argument. It was an honor arguing before the court.
Council seeks permission.
issue number 1 and issue number 2, the council and the corresponding notification number 4 and issue number 2.
Yes.
So if the Honorable Bench permits, the council will be dealing with the 4th issue first and the 3rd issue. The 4th issue is about whether the use of AI algorithm to predict criminal behavior violates right to privacy guaranteed under Article 21 of the Constitution of Bharat. The council seeks to answer in negative manner. Utilization of AI algorithm for predicting criminal behavior doesn't violate right to privacy guaranteed under Article 21 of the Constitution of Bharat. The council will make good of this argument in 3-fold submissions. The first submission would be right to privacy is not an absolute right and still satisfies the elements of reasonable restriction. The second submission would be right to personal reputation and dignity is upheld by ensuring non-disclosure of data. And third submission would be there have been a legal framework which has been designed to uphold the sanctity of data security. Coming to the first submission, Your Lordship, the government of Bharat Nadu is aiming to reduce the crime rates through implementing, developing AI algorithms. Since there have been an increase in number of crime rates and also less resources, we are taking help of, we are implementing AI algorithm operations. This strategy is designed to optimize the resources and to enhance the decision making in criminal justice system, Your Lordship. And also along with that, we have adopted machine learning techniques such as logical regression, random forest, support vector machine, neural networks, and language processing. Your Lordship, even though one technique might fail, but not all the techniques of machine learning will fail. Your Lordship, there are various circumstances, but when it comes to collection of data, the data is collected is belonging to the person who is accused or who is convicted. Your Lordship, there are 3 elements of reasonable restriction. The first one would be legality, that is the existence of law. Your Lordship, the government of Bharat Nadu has passed 2 different laws. The one is law mandating the use of Yuga Dristy in pre-trial detention, bail hearing and sentencing as it is mentioned in the paragraph 11 of our note document. The another law is relating to the collection of data from any individual who either been convicted of crime and which is mentioned in the paragraph 12 of our note proposition. Your Lordship, the Bharat Nadu government is trying to reduce the crime rates within the available means to protect the integrity and the security of the country. Your Lordship, coming to the second element, that is legitimate interest. Here the state is aiming to safeguard public and also to bring effectiveness in the criminal justice system. Your Lordship, here the government is striving to protect and also providing security to the people by taking measures to implement AI algorithms through which our disputes will be solved. As it was held in the justice case Puttaswamy versus Union of India, where the court observed that the bench also ruled that the right to privacy is not an absolute right. It is subject to reasonable restriction. It is because to protect the public interest or welfare. And also there have been a failure on the part of traditional method. The government of Bharat Nadu is introducing AI algorithm. Coming to the third element of reasonable restriction, that is reasonable nexus. Your Lordship, the principle of proportionality which was observed in Maneka Gandhi versus Union of India as well as in the justice case Puttaswamy case, the court observed that any action taken by the government should be connection with the issue. Here, as it is mentioned in the paragraph 12 of our note proposition, the data collected which includes in a very precise manner, Your Lordship, it includes socio-economical, psychological data. All these data are very necessary to determine the behavior of convicted person and also it is very crucial to predict the crime of a convicted person. Your Lordship, Your Lordship, these are the 3 elements of the reasonable restriction which the government of Bharat Nadu has satisfied. Hence, there is no breach of right to privacy. But still, the second submission would be right to person's reputation and dignity is upheld by ensuring non-disclosure of data. Your Lordship, the Crime Record Bureau of Bharat Nadu is entrusted with the responsibility to store and maintain the data. As it is mentioned in Section 4, Subsection 1 of Criminal Procedure Identification Act 2022, it defines collection, storing, preservation of measurement, storing, sharing, dissemination, destruction and disposal of records. Your Lordship, as it was held in Sukhwant Singh was a state of Punjab, the court observed that in order to ensure the safeguarding of individuals' reputation, it is very important to uphold the confidentiality standards. Here, the government of Bharat Nadu is trying to maintain the confidentiality to protect the sensitive information or private information of the convicted person or the accused from by not giving an access to people at large. Your Lordship, there also been various legal frameworks which are designed to uphold the sanctity of data security. So in a more submissive manner, the Council submits that University's source code and training data are unavailable due to national security concerns. Your Lordship, the government of Bharat Nadu is not disclosing source data because if we disclose source data, it might lead to the misuse by the unauthorized person or any person as of matter. It may be due to personal grudge or anything. So in order to stop the misuse, we are not disclosing source code. And also coming to the data. Your Lordship, if there is a breach in data by hacking or by anything, then if there is a breach in data, we agree that there will be there is an infringement of right to privacy. Here the government is making sure that all the data are secure. Therefore, the two reasons why these are the reasons why the government of Bharat Nadu is not disclosing data. Your Lordship, the various legal framework was our Digital Personal Data Protection Act 2023, which is passed in the month of August. And also there is a Information Technologies Act 2000, and also there is Information Technologies Reasonable Security Practices, Procedures, Sensitive Personal Data or Information Rule 2011, and also under the Ministry of Electronics and Information Technology, this ministry has drafted a national data governance framework policy. Your Lordship, there have been a constant efforts made by the government of Bharat Nadu to ensure the sanctity of data security. Your Lordship, if any modification occurs in the future, or if there is any changes, those changes will be adapted in our AI algorithm operation. So, by fulfilling all these elements, the Council for the respondent submits that there is no violation of right to privacy, which is entrusted in Article 21 of the Constitution of Bharat Nadu, Your Lordship.
See, the whole argument is that data is not accessible to third person.
Yes, Your Lordship.
Should not be accused taking
Your Lordship, accused is not a third person, Your Lordship.
He is not third person.
Yes, Your Lordship.
He is against the 21 people.
Your Lordship, we are collecting
You
the...
need to prevent him from hallucinating. Not for right way, or for the time when the sentence is to be imposed. It is not valid law.
Your Lordship, in the interest of national security, we are using the data. And also our concerns about...
National interest is not there.
Your Lordship, our concerns
He
about...
has faced his right. Question is, he is doing the risk. For that purpose, you are making the right. National interest is not.
Your Lordship, we have... Your Lordship, there have been a issuance of charge sheet which mentions all the...
Is there a mention of data in the charge sheet? The dristy in the charge
No, Your
sheet?
Lordship, the data is not
You
mentioned. The
disclose that
reasons...
information in the charge sheet.
Your Lordship, the charge sheet
How do you
is...
claim a charge?
Charge sheet after the
How
investigation...
do you claim a charge? What comments is there?
Your Lordship, all the criminal procedures will be followed before giving the
Will you
judgment.
disclose this information in the charge or not?
No, Your Lordship.
Is it not affected?
Your Lordship, the data itself is not a bias. As it is mentioned in various, the data which is defined in the paragraph 12 of our mode proposition, we are taking into consideration about age, gender, race, because there have been instances where particular age group are committing a lot of offences. It's just an instance, Your Lordship. And we are also taking mental record. If a person is mentally unstable, due to instability of his mind, there might be a chance of committing a crime. Your Lordship, there are various factors. So depending upon the case, depending upon the circumstances, we are applying the data. We are not collecting everybody's data. Yes, Your Lordship.
7 CRS. Previous conviction. There must be a specific charge.
Your Lordship,
Yeah.
is Your Lordship, section
211.
11
Plus 7.
plus 7.
is Your Lordship. If the accused having been previously convicted of any offence is liable by reason of such previous conviction to enhance punishment or punishment of different kind for a subsequent offence, and it is intended to prove such previous conviction for the purpose of affecting the punishment which the court may think fit to award for the subsequent offence, the fact, date and place of previous conviction shall be stated in the charge, and if such statement has been omitted, the court may add it at any time before sentence is passed.
Now this Yugadrishti
Is your
else data what is previous conviction. You suppress it. There is no opportunity for him to defend.
However, if the accused feels that is unjust or such recommend, anyway the accused will not have the knowledge of AA report. So ultimately, it is a judge who gives the judgment.
He wants to say, I am not involved, I am not convicted in case of here. It's false information. That's defense he wants to take.
Your Lordship, in that circumstances, the government of Bharat Nadu will make a separate committee to discuss about certain actions which are lacking. But Your Lordship,
See, he is already convicted. Now sentence is to be awarded. Should he wait?
it is
till
at
martial
the
law?
no, Your Lordship, it is at the discretion of the judge. Judges passes the judgment. Therefore, at the end of the case,
Therefore, don't you think that the university does not pass the test of
Your Lordship, if the accused is not satisfied with the case, he still can approach higher courts
That's
for
different.
appeal.
Going on is different. You are in the trial stage.
Your Lordship, the data itself is not biased, and why should
How
we?
do you say it's not biased? He says it is against me.
Your Lordship, in the instant case,
So do not give him a chance to defend himself.
Your Lordship, in the instant case, as my co-counsel read, if the person whoever has been accused or convicted can make a request to the judge, and also if he feels it is biased, Your Lordship, there have been a statistical report which proved that all these data, there is accuracy in the prediction of artificial intelligence algorithm, and also any reports made by the artificial intelligence is just a guiding principle, Your Lordship. It is not binding on the judges. Therefore, the accused still have a chance. Ultimately, the judge will look into this aspect, Your Lordship.
The prosecution will provide indications about his previous conviction, standing in the society. Even there is an act called probation officer, where the judge can direct probation officers to provide all this information to decide whether he is to release on probation or to be subjected to imprisonment or by testimony. Why do you want to separate the two? Separate there are mechanisms.
Your Lordship, in the interest of expediting the criminal justice system, we are introducing AI algorithm, and also along with that, the state has various legitimate interests. It's not only about expediting; it also has a aim to prevent the crime rates, and it also has.
It's preventive detention. Preventive detention.
Your Lordship,
When an accused is detained, the preventive detention, there must be grounds. Without grounds, he can't be detained.
Your Lordship, the data which are collected is in the paragraph 7, in the paragraph 4 of our note problem, it is mentioned that who are the high risk individuals. We are collecting the data of person who are at high risk individuals. Therefore, here the government of Bharat Nadu is trying to improve the efficiency and effectiveness of the criminal justice system. We are not collecting random persons' data or people at. We are not collecting every individual data. We are collecting only risk individuals' data. And also the written statement of if there is any written.
Yeah, government of Bharat Nadu has framed any rules. It has to be applicable in the Yugadrushti in criminal trials. If it is opposed to provisions of section 207 of CRPC, it is opposed to section 236 of CRPC, it is opposed to section 75 of IPC.
Have you brought amendments to CRPC? Corresponding amendments to CRPC?
And also Article 21.
Your Lordship, if there is any written statement of the accused, he will state that he is a law-abiding citizen with no criminal record. Then here the judge should be very careful while giving the judgment. So, Your Lordship, and also right to privacy, coming to the third issue, that is right to privacy is not been violated because the state has taken all the measures to fulfill the elements which are mentioned in the reason, which are in the reasonable restriction. That is the reason why it is not violating the right to privacy, Your Lordship. If the honourable bench permits, the council will move on with issue number 4.
Yes.
Issue number 4 will be the use of AI algorithm. Whether the use of AI algorithm to predict criminal behavior violates right to privacy guaranteed under Article 21 of the Constitution of Bharat. The council seeks to answer in negative, my lord. Utilization of AI algorithm. This is issue 3. Your lordship, the use of AI algorithm do not raise concern about transparency, accountability and due process. The council will make good of this argument in 6-fold submission. The first submission would be the non-disclosure of data which is mentioned in paragraph 14. So the transparency which needs to be approached should be with the caution, and also when it comes to the context which involves national security, some data which is used to train the AI model are sensitive information or it is a private information. So releasing will could lead the misuse of such data. Your lordship, there is a striking the right balance between openness and sensitive information is more crucial. And also AI algorithm which are created by taking the expert's opinion, which is mentioned in the paragraph 7 of our move proposition, that it includes it includes a team consisting of data scientists, machine learning engineers, judges, lawyers, legal researchers, etc. Your lordship, and also there have been a rigorously tested, validating and constantly refined upon the feedback of legal concept. So to ensure reliability, to ensure accuracy and any ethical consideration, all the refined is based on the feedback. So your lordship, the state government has taken all the measures, all the steps to possibly minimize the potential for bias and also errors in AI algorithm. The final say is given for the judges in sentencing and in detention, which is mentioned in the paragraph 18 of our new proposition. Here, the AI generated reports in criminal justice system will aid the judge by analyzing the data. It offers insights, it highlights the factors like criminal history, and also human oversight is very crucial as judges retain the final authority by considering legal, ethical and individual aspects. Your lordship, that the sixth and last submission would be Yugadrushti has been statistically proven more accurate in predicting recidivism. That is, AI-generated reports can analyze vast amount of data to identify patterns that may not be apparent to human observers. And also, your lordship, by saving the cost, we are utilizing such funds in legal aid and we are utilizing such funds for the public welfare. Your lordship, there is a positive instance where whereby utilizing or whereby bringing AI algorithm operation in criminal justice system, it is doing optimum utilization of resources. Additionally, machine learning algorithms will also be continuously improved and also adapted as a process of by taking more information or by enhancing any predictive capabilities over a time. So over a time we adapt such changes in AI algorithm operation, which serves at the best of social interest at large. If the honourable beings is satisfied with issue number 3 and issue number 4, the council will move on with prayer. Wherefore, may it please the Honourable Supreme Court, in the light of facts and circumstances of the case, issues raised, arguments advanced, and authorities cited, the respondent prays that of this Honourable Court may be pleased to adjudge, rule upon, and determine the following. The use of AI does not violate right to fair trial under Article 21 of the Constitution of Bharat. That the use of AI does not violate Article 14 as it does not affect any community disproportionately. The use of AI does not violate right to privacy under Article 21 of the Constitution and or pass any other order it may deem fit in the interest of justice, equity and good conscience, all of which is most respectfully prayed and humbly submitted. Is honored arguing before the Honourable Court.
Yes.
The council seeks permission to commence the rebuttal. Firstly, Your Lordship, the learned council had adverted to the presumption of constitutionality of the law. Your Lordship, such presumption exists only unless manifest arbitrariness does not exist. However, the law in this case is manifestly arbitrary as proved by the counsels for the petitioners. Secondly, the council has reiterated time and again that only the data of those mentioned in paragraph 12 of the moot proposition has been collected. Your Lordship, this includes pre-trial detainees, bail applications, those under preventive detention, and even those who stand as security for bail application and for maintenance of peace and order. This includes a substantial population, Your Lordship. Considering that the prisons of the country are overflowing due to the backlog of cases, the number of pre-trial detainees in itself is very high. Secondly, Your Lordships, the council has stated that jurisprudentially, AI is equivalent to a charge sheet. Your Lordship, a prediction is not equivalent to a raw data. A conclusion by an AI is not equivalent to information by a charge sheet. Your Lordship, further, the council has stated that not all techniques will fail, even if one technique does. Your Lordship, it is adequate if even one technique fails to create a bias in the AI. Further, Your Lordship, the council for petitioner has argued that even the collection of certain data is violation of right to privacy. Hence, anonymity is not a justification for collection of such data. With regards to procedural safeguards, Your Lordships, the council had adverted to the Digital Data Protection Act of 2023 passed very recently in August. Your Lordship, Section 30 of the Act exempts government agencies in collection of data. Hence, there is no duty on the government to safeguard such data. Further, Your Lordships, finally, the council has stated that it is up to the accused to go forward to the court and state that I am of a particular race and might be prejudiced by the AI. Your Lordships, this places a reverse burden on the accused in each case just by nature that he belongs to a particular community, which in itself is violative of Article 14, Your Lordships. Further, Your Lordships, the council stated that a committee may be constituted to deliberate upon the bias. Your Lordship, this should have been a proactive step rather than a reactive step, as so many people rot in prisons due to the prejudices perpetuated by the AI. Further, Your Lordships, the council has stated that proportionality is when the data collected is in connection with the issue. No, Your Lordships, the council seeks to refute this by stating that proportionality is when the data collected is in a minimal amount while infringing the right of privacy. Finally, Your Lordships, the council has stated with respect to Article 14 that unconscious and unintentional discrimination can be pardoned. Your Lordship, if such a contention is encouraged, then every time the legislature or the executive can easily take up a contention that the discrimination was unintentional, and this shall not stand scrutiny with this case. The council seeks permission to retire.
Council seek permission to approve. What's your bless? Yes, madam. We have reserved 2 minutes for sir. Coming to the first for sir rebuttal, that the presumption of validity of statute only lies under Article 14. When the challenge is for Article 19 and 21, it is the duty of the state to say that there is reasonable restriction, but only under 14, Article 14, there is a presumption of constitutionality as held under Bachchan Singh. My lord, the council submitted about the narrowest of data should be collected. The state is only collecting narrowest of data and only relevant data. If he is accused in a criminal, in a corruption case, will only collect his financial data so that verify that there is no disproportionate asset. If he is a psychotic who is serial killer, we will collect his mental data. We are not collecting all of the data under the definition of data. Coming to the systems used by AI, we have used several of them. The first one is logic regression. Logic regression is yes or no, 0 or 1. If when it will be only used when the answer is going to be 0 or 1. Else neural engineering will be used. My lord, can I please one last? The council submitted that it should be a proactive action, not a action that has been taken after bringing us such data. Well, it is the humble contention that the allegations of the petitioners are based on assumption and presumption that the data is biased. In fact, the data is not biased, and it has been statistically proven as per note proposition that the predictions of AI is accurate. With this, I rest my service. It was an honor.
As the proceeding has come to end, I request everyone to rise.